You went through the effort to set up a trust. You paid the expensive attorney, signed the paperwork, maybe even felt that sigh of relief. But here's the hard truth. Just having a trust document doesn't mean your estate plan will actually work when it's needed most. We see it all the time. Trusts that are technically created, you've got the legal documents, but they're still unfunded, outdated, or flat out ineffective. And when that happens, your family is left with the same mess that you thought you were protecting them from. In today's video, we're breaking down 4 common problems that we see with our clients' existing trusts, including things like why your trust might not be protecting anything at all, the #1 mistake that could destroy the legacy you intended to leave, and how your trust may not even be valid in your current state. Let's dig in. Mistake number 1. You never put the trust to work. Creating a trust is only the first step. To make it effective, you have to fund the trust. That means retitling assets like your home, savings, or investment accounts into the name of the trust, or listing the trust as a beneficiary on things like retirement accounts and life insurance. Your trust is like an empty safe. Nice to look at, but useless when it counts. And that usually means your loved ones are headed back to the probate court, the exact thing that your trust was meant to avoid. So where do you start? The first thing that you want to do is check your estate plan documents to see if your attorney already left you some specific instructions about how to title your accounts and how to name beneficiaries. Many times, they write this down for you. You probably looked at it way back when and just forgot about it. Next, understand that things like life insurance and retirement accounts typically don't need to be moved into the name of the trust. Most of the time, these assets can simply have the trust named as a beneficiary or contingent beneficiary. Keep in mind that typically, both life insurance and real estate will maintain your spouse as the primary beneficiary, and then sometimes it makes sense to make the trust your contingent beneficiary. For things like real estate, businesses, and other less tangible assets, you should consult with your attorney on the status of these items and confirm if they should be owned by your trust or not. When you first set up your trust, maybe your kids were toddlers or still in school. So you wrote in specific ages when they received their inheritance, like maybe age 25 or 30. But now your kids are in their 40s, financially responsible, maybe with kids on their own, and your trust is still written with those old rules. Having left it this way, it may create delays, frustration, or even unintended restrictions on how your kids could ultimately access the funds. So your trust should grow with your family. If it's based on an outdated version of your life, it might not reflect your real intentions anymore. Many older trusts say something like, distribute all assets to my child or beneficiaries at age 25. On paper, that sounds fine, but in real life, giving somebody a lump sum inheritance of $2, $3, $4, $5, or $10 million may not be the right way to go about it. Not to mention, if you do, you're going to leave that money subject to things like divorce, lawsuits, claims and creditors, or just plain inexperience. So keep in mind, once the assets are distributed from the trust, they are no longer protected from things like these. You can have the language in your trust updated for things like long-term holding, controlled access, built-in protections, so that your assets continue to grow and stay protected even after you're gone. Updating the language in your documents to state that the funds should remain in trust but are available to be used by the trustees is one way to help ensure the generational wealth that most folks are looking to accomplish. Updating the language in your documents to state that the funds should remain in trust but are available to be used by the trustee is one way to help ensure generational wealth, versus simply distributing everything from the trust at a certain age and leaving your legacy to chance. Ask yourself this: do I want to give my children money, or do I want to leave them a legacy? What I mean by this is that once upon a time, it may have been written in the correct state, but since then, you've moved, you retired, you bought your dream home, maybe you moved closer to your kids, and you're no longer in a state anywhere close to where you used to be. We see a lot of Northerners coming down south here to North Carolina with trusts written in New York, Connecticut, and Massachusetts. If your trust was written in one state, but you've since moved to another, it may not align with your new home's laws. Each state has different probate rules, tax regulations, and trustee requirements. At best, it could create confusion. At worst, it could lead to court challenges or delays and excess attorney's fees. If you've moved, even just a few years ago, it's worth having your trust reviewed and updated to match your current state of residence. A trust isn't a set it and forget it document. It's a living tool. And if it's not reviewed and maintained, it might fail when your family needs it most. If any of these mistakes sound familiar, you're not alone. We've helped countless families working alongside your attorney to fix, update, and finally put their trust to work the way they were meant to. Don't leave your legacy to chance. Book a time to talk. We'll walk you through what you have, what's missing, and what you need to fix to give your family peace of mind. Click the link in the description or visit our website here to schedule your free consultation. Thanks so much. We look forward to seeing you next time.